My name is Anita Steberg. I'm with the Steberg Law Firm. We are situated in San Jose, California. And today I'm going to talk about a topic which comes up quite often in my practice area. And that is, can you remove a trustee? If a document names a person X as a trustee, can they be removed? And the answer is yes. Can they be removed easily is a different question. But if the trustee is refusing to act, or the trustee is taking inappropriate action, or putting the assets of the trust at risk, or is not doing the proper things that he or she should be doing, a petition can be filed in the probate court. Because I'm in California, this is going to be directed at how it works in California. But a petition is filed in probate court that requests the court remove or suspend the trustee. A suspension is temporary and until the matter can be adjudicated, which is generally a evidentiary hearing where the judge will hear witnesses, the judge will hear testimony, and the judge will make a decision. The judge can, at a status hearing, suspend the trustee, and then later, after the matter is adjudicated, permanently remove the trustee. A suspension is generally temporary, pending the judge making a decision at a later date. And once the trustee is suspended or removed, that trustee no longer has any power over the trust. There are certain things that the court can look for. In fact, the court has the power. It doesn't use it often in my experience, especially in Santa Clara County, but the court has the power to what's called sua sponte, which means a petition is filed, the judge hears something in a hearing, and it makes the judge very concerned. And the judge, on its own decision, can say, I'm going to suspend the trustee. And then generally we will look to the trust document and determine who is the successor trustee, and perhaps the court will appoint that person, or the court will appoint a professional fiduciary. And that generally the court wants the beneficiaries to nominate somebody. The court is not just going to pull a person's name off their hat, but there are professional fiduciaries who are professional trustees, and they can be utilized in situations where the court is removing or suspending the trustee. So what type of things will cause a court to suspend or remove a trustee? If the trustee is putting the assets of the trust at risk, if the trustee is not managing the trust funds properly, if there is what's called self-dealing, and that is just a fancy way of saying that the trustee is somehow benefiting from the trust. If they are not properly managing, such as a common example is there's rental property, and that trustee is not doing anything with the rental property. That rental property, although it could be rented out, the trustee has chosen not to do so. In fact, maybe the trustee is even living in the house and refusing to pay rent. Or perhaps the trustee is refusing to comply with previous court orders or requests for accounting information from the beneficiaries. These are all things that the court will take in consideration and will likely remove a trustee for. So there are ways under the probate code, if the trustee has violated their fiduciary duty to the beneficiaries, the court takes that seriously. And the court will, upon a filing on a petition filed with the court, can and does remove trustees. The trustee is allowed to present a defense. The trustee can even, unless the court specifically says the trustee cannot do this, but the trustee can generally use trust funds to defend himself in a petition for removal. But it is up to the court to decide whether the trustee can use trust funds to do that. And once they are removed, if the trustee is successful in defending their actions, they can go back to the court and request that the trust reimburse them for their attorney's fees. The beneficiaries also, if they prevail, can request that not only are the damages against the trustee personally to make the trust whole, assuming that like the trustee was not renting property and the trust therefore forfeited some amount of rental income. In fashioning a remedy, the court can hold the trustee responsible for the amount of rent plus interest that the trust should have received had the trustee not violated his duty. And the court has the discretion to award the beneficiaries their attorney's fees for prosecuting the action. So the simple action is yes, if the trustee is going rogue or has violated the duties that the trustee has to the beneficiaries, the court can remove the trustee. And if it's serious enough, the court will. How that plays into your individual facts and circumstances is very can be very unique. And there's not a one size fits all answer, unfortunately. But if you would like to talk to us about your facts and your circumstances in your case, where we can talk about it one-on-one in a confidential setting, please feel free to reach out to my law firm and we can set an appointment to talk to you about that. You just do that by calling 408-573-1122. Thank you so much for joining me. And if you know of anybody that would find this of service or of value, please share this with them. At the Steberg Law Firm, we like to share our knowledge. We believe that it makes our communities better. So if somebody is struggling with this issue, please share this with them because it'll let them know there may be some things that they can do. A lot of times when a beneficiary is in the situation, they feel very powerless. But there are things that they can do to hold the trustee accountable and to kind of put the feet to the fire. So we can talk to them about their individual situation. Thank you so much, and I hope you have a great rest of the day.